Hello, everybody, and welcome to today's Learning Lab. This is Nils Hallerström. I'm in Luxembourg. I have some internet issues, so I'm addressing you now by phone. I hope I will fix that for the Q&A session in a few minutes. We have Doug Walker with us, who's going to talk about airline restructurings in time of COVID. Doug is with Seabury Capital. He's a managing director there. And as such, he advises airlines and investors on financings, fleet acquisitions and disposals, on mergers and restructurings. Before Seabury, Doug was with Skyworks Capital, and before that with SMBC Aviation Capital, which was RBS, and he was with RBS as well. And then before that, he was senior counsel for United Airlines during the bankruptcy filing in 2002, which was at that time the biggest airline bankruptcy filing ever. And before United, Doug was associate at the law firm Perkins and Coie. Doug is also an owner, and he flies aircraft for fun, and he's on the board of Airwheel Investors and American Air Power Museum in Farmingdale on Long Island. Doug has also been on the board of the Wings Club in New York. Before I hand over to Doug, I just want to mention that we have more events coming up in the Learning Lab series. On December 1, we are planning to have Li Lu talk about the airline and leasing landscape in China, which I think is an interesting region, given that they are probably the region that is coming out of the pandemic before everybody else. And we're going to have on December 15 a session on the capital markets, how that fares in the space of aviation during this crisis. And on 12th of January, we're going to talk about lessor risk management. And on February 2nd, about lessor funding. But more details of that to follow on ISTAT's website, istat.org. So now I hand over to Doug Walker.
Thank you, Niels, and good morning, good afternoon, good evening, everyone. I will share my screen and maximize the view. So hopefully this is reasonably legible. So Niels and ISTAT have asked that we share a few thoughts on restructurings generally and on our observations from the recent crisis. And so I'm very happy to be here today to do that with you. Before we begin, I think it may be worth spending a moment to discuss what we mean by restructurings. The term is used fairly loosely, and it can encompass quite a number of things. I think for these purposes, for today, I think what we're really talking about are the really massive wholesale changes to a business, the fundamental changes, and particularly changes to key contractual relationships that really cannot be accomplished through ordinary course practices. So that could include changes to collective bargaining agreements with labor. It could be changes to aircraft financings, the early return of aircraft. It could be material changes to OEM commitments or MRO contracts. It's typically a number of different things. Restructuring is one of the neat things about this space. It's generally unpleasant for all the parties involved. But on an intellectual or academic level, it can be fascinating because they're each a little bit different. And so I would say even today with many common fact patterns in COVID, each of the restructurings themselves are different. They're tailored to the unique circumstances. But I think for today's conversation, we're talking about the confluence of factors where you have the magnitude of the changes and the speed with which they have to be made, combining to make it virtually impossible for an airline to undertake these in a more traditional manner. So that for today's purposes, that's the focus. So what does that mean? So the first slide, really in the beginning of the conversation, I think is logically around some of the areas that are often implicated in a restructuring. Now it varies, as I say. No two are identical. They're truly unique. It's a lot less cookie cutter than, say, aircraft financing on the front end. or new order, the new order process. This is more bespoke in each application, but you do see themes and trends and patterns. And I would say this graphic is by no means exhaustive. It's more illustrative, but these are the kinds of areas, the kinds of treatments that are often required to help navigate back to profitability. I would start in that kind of 10, 11 o'clock position, the little honeycomb on liquidity and liability management. These are typically all critical, but I would say that's usually the first area of focus. We hear often from clients that they have a problem, and that the problem is principally that they don't have enough cash, and that they are worried about dangerously low liquidity and the ability to navigate sort of either a carrier-specific problem or a more macroeconomic crisis. That isn't in and of itself often the primary problem. It's often more of a symptom of other problems, but it is something in any event that needs to be addressed immediately. And so we would typically say that an airline, whether they're doing this on their own or with the help of an advisor, they need to produce very, very accurate, very detailed cash forecasts, so they know exactly what they have and exactly what will be required over the weeks and months ahead on a daily basis, and also immediately implement a cash conservation program to make sure that they are conserving as much as is humanly possible. And then, of course, they need to begin to think about ways to raise additional liquidity throughout the process, or at a minimum at the end of the process, once they've started to pull the plan together. I would say typically the next most critical would be a reassessment of the network. In some restructurings, that isn't really the issue, but I would say more often than not, it's at least part of the problem, either because the network was underperforming already, or because events have overtaken it and the macro changes in demand have now required a re-optimization. So we would typically say that you want to revisit that with a high degree of objectivity, to see what's working and what's not, and what's sustainable in the new environment, and then to do everything possible to work with sales and distribution and revenue management to make sure that you're closing any gaps with the competition and you're harvesting as much value from that network as you possibly can. I would say, and that, of course, that the next, in my experience anyway, the next logical extension of that is then into the fleet, because whatever you've done to the network tends to spill over into the fleet, and it's almost inevitable that some level of change will be required, and that usually means resizing or reshaping. So the total capacity may or may not remain constant, certainly in COVID, and we'll talk about this in a few minutes. The requirements almost globally have come down dramatically for metal. So in this case, we're talking about reducing the size, but often we're also looking to re-optimize in terms of the shape, meaning the different mix of aircraft for the newly optimized network. And then, of course, within the fleet, there's a high degree of interrelationship among these different areas, and within the fleet, that's often a source of liquidity, either meaning through the sale of owned assets that may be surplus to the requirements, and or through the financing or refinancing of assets within the portfolio. On the labor side, we've seen in different cycles that can be more or less a core focus of a restructuring. Certainly in prior cycles, it's played a pretty significant role. It can be, and I think indeed still through this crisis is relevant, both with regard to the size of the workforce. We've seen with the CARES Act and so forth, government support, airlines have been able to maintain payrolls, some airlines anyway, through a certain point in time, but one way or another, a certain amount of contraction is necessary, voluntarily or involuntarily. There may be requirements to renegotiate CBAs to reduce wages or to improve work rules and flexibility, particularly in this COVID environment where we have sort of more, more frankly, more parking than flying lately. So labor almost always will play a part, if not a leading part of the process. You have other costs. This honeycomb matrix would be sort of quite a bit larger. This is sort of what conveniently fits on the page. So we've collapsed quite a bit here, but you can think of any number of a dozen, half dozen or a dozen other areas within a typical airline that can be revisited for appropriateness in the restructuring environment. That could be You can think about primary vendor contracts. You can think about ground handling, maintenance, catering, and so forth. So long list of areas that should, in most restructurings, at least be benchmarked. They may not all be uncompetitive. In fact, none of them may be uncompetitive. You may look and find that in fact you're performing well in those areas and that's not the focus. But more often than not, there's at least some opportunity for improvement there. And in the context of a restructuring, almost by definition, every dollar matters. And then finally, we can think about strategic combinations that maybe mean M&A, but more typically in this environment, I think it would mean JVs and alliances. And certainly JVs pre-COVID were a very popular and very effective way to act as a force multiplier and to increase the scale and connectivity of the network without necessarily the corresponding capex and risk that would otherwise be associated with organic own metal growth. So there are quite a number of factors. As I say, this is not exhaustive, but this would give an idea of the kinds of areas that are often implicated. And that leads into what we would say is the integrated approach to a typical restructuring. And so you really want to begin by developing a plan, and then you move into the implementation of that plan. And then more often than not, you end up raising liquidity at the end of the plan once the business is more stable and financeable. So in the development of the plan, we would say typically you want to be as holistic and comprehensive as possible. Airline restructurings that fail, in our experience, tend to fail, and in my observation, tend to fail more because they were too narrow than because they were too broad. Usually, it means that there's a temptation to kick the can, right? Not to address a certain problem because it's too difficult, or it's too politically toxic, or it's sort of a sacred cow. And so what we often find is that the lack of breadth and the unwillingness to tackle some of the broader, more challenging issues and to focus instead on the easier targets is often one of the things that restrains the carrier's ability to successfully restructure. And so we would say it should be as comprehensive and as objective as possible. And that means an organizational structure to support the plan from the top down. It usually, as I say, means revisiting the network. That isn't always part of the problem, but it often requires some degree of optimization, and in many cases is a significant part of the solution. We talked about the fleet, making sure that is tailored to the new network. We see carriers frequently holding on to assets because there's a sort of a psychological attachment to them. It's a wide body that's associated with the brand of the carrier. It's the flagship, and it's new, it's exciting, or in the network, so-called trophy flying, where the airline has assessed that there's a certain market that they just can't exit because they've always been flying there, because they need to have that on the route map. And that's not always the right thing to do. And so being objective with regard to what works and what doesn't, and addressing the network and the fleet and exiting markets and capacity that isn't working is usually a really critical and indispensable element of a successful plan. Of course, you need to produce very, very detailed and very credible financial forecasts. We see, and we'll talk about this a little bit later, we see in the current market that not every airline is doing that. And it's understandable because so many airlines are in a triage mode where they're fighting fires in every direction. But in order to have a sensible roadmap for themselves, and in order to persuade other key stakeholders to participate, it's really essential that you not only do the hard work in developing the plan, but then you present it in a credible way so that others can see and buy into what you're proposing. And that then leads into that roadmap, the ability to produce and share those forecasts and projections then allows you to see what you can become. That's the opportunity at the end of all of this, and working backwards, that's the plan to get there. And then to get from here to there, unfortunately, usually requires some level of concession from third parties. A lot of what I've just discussed can be done organically and internally without breaking too many commitments to other parties. But the sad reality, unfortunately, is that in many cases it means going back to lessors or to lenders or to employees or to suppliers and asking them to permit modification of those pre-existing commitments. As you move into the implementation, you're then taking everything that we see in this left column, the plan development, and you're moving into an execution phase. So that means making those changes to the organizational structure, means taking voluntarily those initial steps to reduce headquarters staff and to reduce sort of those things you can do consensually and without negotiation with the labor groups. It means presenting then those required changes to key stakeholders. This could be labor unions, it could be lessors and lenders, it could be OEMs, it could be sort of traditional trade vendors. And then you're presenting and defending the asks of these stakeholders and the logic or methodology behind them, so that they can understand both what it is that you need and why you need it, and how that manifests itself in their specific request. You're then, of course, negotiating and documenting the support they hopefully ultimately provide, and then you're working with the subject matter experts in each of the relevant areas in that prior slide to do everything you can. While you're restructuring externally, you should also be doing everything you can internally to make the most of what you've already got. And then finally, at the end of this process, if it's gone to plan, you have a better, more stable, more financeable business. And at that point, you can launch the usual sort of efforts to raise additional capital. It may be debt, maybe equity, maybe hybrid, but you can identify what you need in terms of new capital and the likely parties who would have an appetite for that type of opportunity. And by the end of this process, which could be 6 months, could be 8 months, could be 12 months or longer, you've worked through the cycle and you've come back on the back end with improvements to the revenue side of the equation, improvements to the cost side of the equation, and significantly new liquidity to help you get back on your feet. So then, as you think about the elements of a restructuring, again, they're all different. They're each unique, which is part of the intellectual appeal, I think, of this practice area. But they follow typical patterns, and we would say this is almost non-negotiable. We would say that these three, if you just think about these three blue boxes, this would be a key takeaway. We would argue, and I would certainly argue, that there needs to be a demonstration of the need for help. It's not enough to say you want it. You have to prove that you need it. And what that means is that you don't have the liquidity to weather the storm. What you're doing now isn't good enough. It's not sustainable. You can't kick the can any further. You need to demonstrate that everyone is concerned. They should be concerned. You're concerned that what's happening today is not sustainable, but that there is eventually an opportunity for success. And then once that's been articulated, that vision now has to be shared among all of the key constituencies, right? So you have to agree on what it is that you're targeting. Okay, we've established that whatever we're doing now isn't working, or it was working, but the landscape has changed. Fine, but now where are we going? Right? What's the strategy? What's the goal? What's the vision? And what are the elements? And then what's the day-to-day and week-to-week path to getting there? Because it's not enough to have a credible vision. You also have to make sure that you can in fact get there, and that includes the daily and weekly cash forecast. It includes updates on what other stakeholders are doing and how those discussions and negotiations are progressing. So it's a bit of a high wire act, but if you have enough of a shared vision across the different constituencies, then you should be able to move into the third column, which is the alignment of interests and incentives. And so if everyone can see that there's indeed a need to do something, but there's also a reward, a collective reward at the end of the process for successfully navigating this, then you've aligned interests and you're all pulling in the same direction. And that includes management, it includes labor, it includes your key vendors, it includes your financiers, the banks and lessors, it includes the OEMs, among other stakeholders. Again, this is not exhaustive, but these tend to be the areas that are most active in a typical airline structure. So we often say to clients that you can't really make anyone do anything, even in Chapter 11, and we'll talk about that separately in a moment. So you have to persuade counterparties that it's actually in their interest to help you. It's not really a handout per se, but it's an acknowledgement that you're in this together. It's a long-term partnership, and there's an ecosystem here, and there's a symbiotic relationship here, and it's in everyone's interest to participate so that everyone ends up at the back end of this process, whether that's in 12 or 24 or 36 months, in a better position than they are today. So if you can do each of these three things, the odds are reasonably, reasonably in your favor. Now, how that then is implemented can vary considerably. There are broadly, I would say, two types of restructurings. There are the out-of-court restructurings, and there are the judicial proceedings. Out-of-court speaks for itself. It can be whatever you want it to be. It's highly flexible. It can be customized in terms of the substance and the process as required. So you and the counterparties can agree to approach it in whichever way you think is best. It can be fairly narrowly tailored, or it can be fairly broad. And in some cases, it can actually be very, very fast. You can do this in a matter of a few months if you have the right fact pattern. There are, however, a number of challenges. The most obvious of which is that it requires essentially 100% participation. And why is that? Well, for two reasons, typically. Number one, because if you are modeling a certain level of concession, particularly from financiers, but it could be from OEMs and so forth as well, you're not modeling that you're going to win here and lose there. You're saying, I need there should be some logical defensible methodology, but I need an X% reduction in capacity, or a Y% reduction in current payables, or a Z reduction in long-term costs, whatever it may be. And you're modeling that across the entire business. And so in order to hit those targets, there may be a little bit of margin, a little bit of cushion, but broadly you need people to participate. And so out of court, it's very hard. You're herding cats. And so you have a range of responses. There will be carriers, or excuse me, there will be counterparties that will engage quickly, either because that's sort of the nature, that's their DNA. They particularly value the partnership and they want to be seen as cooperative and collaborative, or because they simply recognize that it's in their best interest. But there will be some that will engage more quickly, but there often are some who will be tempted to sit back and to hope that others participate and solve the problem for them. So it can be a very difficult process. When it's done well, it's the most elegant, I would say, of the three, because it's the least controversial, it's the least labor intensive, and it's usually the fastest, and it's almost always the least expensive from a sort of an out-of-pocket cost perspective. So if it's done well, and if it's the right fact pattern, it's usually a great result. But again, it's herding cats, and you need 100%. The other reason, though, that you need the 100% is because what you'll tend to find is that even if you had enough of a cushion in the plan that you really didn't need economically, in terms of the cost, the capacity, and so forth, even if you commercially didn't need 100% or something near 100% participation, and you could afford to do with less, what you will often find, not unreasonably, is that counterparties effectively demand that you get 100% or something close to it, because they don't want that free riding. And so what you'll typically find is that you'll have certain parties who will engage more quickly and more generously, but who are not willing to do this on their own. And so even if you didn't want or need broader participation for your own reasons, you will often find that it's necessary from the counterparty's perspective. And having been on both sides of the table and spent quite a bit of my career on that side of the table, I can't blame them. That's, nobody wants to participate and then find that their peers or their competitors sat on the sidelines. And so for a couple of reasons, you really do need almost unanimity there, and that's very hard to do when it's sometimes difficult to get people to engage in the first instance. And then the final issue or complexity there is that even if you have effectively 100% engagement of those parties with whom you can meet, there are other groups of creditors who structurally are just not available to you. And you can think about bondholders, think about secured or unsecured bondholders, WETC participants, and so forth. Very hard to negotiate with them, even if they wanted to participate. It's too fragmented, and it's not impossible, but it's very difficult. Back in my United days, back almost 20 years ago, after 9/11, when I was called by United to to join what was then a sort of an out-of-court effort, and what became, as Neil said, the largest airline bankruptcy in history. We actually did negotiate with the 4 WTCs we had, but it was very challenging, and it was almost truly unique in the way they came together in an ad hoc committee behind a single financial advisor and a single law firm. And even then, we were pushing the limits as to sort of what could be done there. And more practically and more typically, those types of deals are almost untouchable out of court. And that was in Chapter 11. I think had we done that, that was hard enough with the full powers of bankruptcy in the U.S. Had we attempted that in a purely out of court manner, I think we would have gotten absolutely nowhere. So I think out of court is always, it's logically where almost everybody starts the process, but it's not always the right tool for the job. When you then look at the judicial side, it's subdivided, I would say, between a scheme of arrangement, which has lately become somewhat popular, and a more traditional bankruptcy or insolvency process. So a scheme which is really limited to, or principally limited to the UK and Ireland. We've seen it with Virgin and with NAC. It's worked well. It's really more of a corporate. It's a sort of a corporate statutory product, not an insolvency proceeding per se. So it's a little bit less flexible and a little bit less debtor friendly. You do need 3/4 in value and a majority in number for a given class. So that's a fairly meaningful reduction from the effective unanimity that we talked about a minute ago in the out-of-court context. But it's still a relatively high bar. There is a core cram down within a class, meaning that you can impose on those dissenters. If you get the 3/4, you don't have to seek and secure the consent of the remaining quarter. So that's helpful, but 3/4 is a reasonably high bar. And then more recently, the new insolvency law does allow for cross-class cram down. So you now have potentially the ability to do something more Chapter 11-like, where you could potentially fall short of it within a certain class and still achieve the savings that you need. But it isn't as perfectly engineered. It's not initially engineered for an insolvency type process. So it's a useful tool. It would be typically a faster process and a less expensive process than an insolvency proceeding. So there's a middle space, I think, between an out-of-court process, a fully out-of-court process, and a full-blown bankruptcy proceeding. And if you happen to fall within there, if the facts and circumstances align with that kind of a tool, it can be the best approach. But then at the far right, you see here the bankruptcy process. This could be Chapter 11 in the U.S., which is probably the gold standard. It could be CCAA in Canada, which is a very similar and very powerful law. It could be the insolvency laws of any of a number of other jurisdictions. And there typically you see 2/3 in value. So again, it's a further reduction from the scheme and a significant reduction from what you would be required in all sort of practical purposes to achieve out of court. And so it's more flexible in that regard and more debtor friendly in that regard. But it's actually pretty rigid in a number of other ways, and we can talk about those. So the good news is that it forces stakeholders, all of them, to actively participate. There's virtually no way to ignore a Chapter 11 or similar filing. And it does, as a result, typically yield the greatest concessions for an airline. And in the U.S. in particular, with the long arm of the U.S. and the sort of the global enforceability, it tends to give you one-stop shopping across quite a number of jurisdictions. There are limitations to that, but in general, it's a very efficient process procedurally because you can file in the U.S. and know that those judgments likely will be enforced elsewhere and will be for all intents and purposes binding on the counterparties. So there are, and we'll talk. I'll drill down on Chapter 11 in a moment because I think it's such a powerful tool. But I would mention that I would mention quickly that there can be a couple of different varieties of Chapter 11s. What we've seen lately with Avianca and LATAM and Aeromexico is what would be known as a traditional or sort of a free fall Chapter 11, where you file first and then you work through the process, which is typically a year or so in length. And you effectively file primarily because of an urgent need for the automatic stay. There's something coming due. There's a payment coming due that's that's unaffordable, or there are breakdowns with discussions with one or more counterparties, and you're taking operational risk if you don't file. And so in that case, in a traditional case, you file primarily for the protections first, and then with the ability, with the automatic stay and the ability to then reach out in a more measured way with counterparties, you develop the plan and you launch the restructuring process. And during the case, you negotiate, hopefully, deals that work for everyone. And at the end of the case, you present that to the court and you have the plan confirmed, and then you merge. That is by far what's the more typical approach with airline bankruptcies, and we've seen, unfortunately, quite a number of them over the years, from all the way back to virtually the deregulation of the industry in 1978 here in the U.S. So Chapter 11 is often, when we think about Chapter 11 in the U.S. or its equivalents, we often think of the traditional case. But I would mention that there are two other varieties that can be compelling in their own ways, depending on the fact patterns, and those are prearranged or prepackaged cases. I've listed them here in the lightest touch to the quickest and lightest to the most full-blown. The pre-pack Chapter 11 is one in which the negotiations have taken place pre-filing, and you've already solicited the votes such that it's a foregone conclusion for all intents and purposes, right? You know before you file the deals that you're going to do, and the plan, you have the plan already prepared, and you have everyone locked up, and so it's more process than substance, and as a result, it's usually very, very quick. It can be done in a month or in 2 months or something along those lines. In the prearranged, it's a slightly less pre-baked version of a pre-pack, but it's substantially similar in that you have signed restructuring support agreements with each of the counterparties such that you've already negotiated the deals with them, and you have agreed to bind each other pre-filing to those deals such that when you file, you can then assume the RSAs or otherwise honor them and incorporate those into the plan that's filed with the court, soon after you filed for protection. So it's a subtle and probably for most purposes academic distinction, but whether it's prearranged or pre-packed, the idea is that you've actually done most of the work before you file. And so it borrows from, in some ways, it's the best of both worlds, because it's essentially out of court in the sense that it's at its core a consensual collaborative process in which you have sought from creditors what you think you reasonably need, and you have obtained their support and their commitments to the plan, and then you're able to file and memorialize all of this, but without the heartache for counterparties of the uncertainty and the duress of the actual Chapter 11 process. So it's a way to thread the needle, but again, it's not always available, and depending on other commitments and other operational risks that may be facing the business, you may not always have, or an airline may not always have, the luxury of approaching it that way. Chapter 11, generally, whether it's a pre-pack or a prearranged or traditional case, does offer quite a number of benefits to the debtor. These are pretty well known, and I suspect have been discussed already by many of you and by ISTAT and other prior learning labs. But the benefits, the obvious benefits include the predictability of the process, and I've listed that as the first bullet on both the debtor and creditor benefits, because I think it's something that works in everyone's interest, whether you're the lessor or the bank or the OEM or the airline or anyone else in the process. It's good to know how the process will play out before it's even started. Chapter 11 is particularly well known. There's a ton of precedent, and the courts are generally very sophisticated and increasingly expert on airline restructurings. And so there's not a lot of wiggle room. You tend to know before you get there how it's going to play out, and that's comforting for everyone. No one likes being in Chapter 11. No one likes restructuring even out of court. The airlines are no happier to be there than anyone else. But what everyone, I think, appreciates is a degree of familiarity and predictability, so that you're not having to add insult to injury by fumbling around with a process that may be arbitrary or random or otherwise unpredictable. The automatic stay can be extremely helpful to a debtor in the prearranged or pre-pack context. It's not really relevant, but in a traditional case, it's essential, and it can be the difference between survival and frankly liquidation. A huge benefit in any of those contexts, pre-pack or otherwise, is the availability of DIP financing, which makes the airline more financeable during the case as opposed to only at the end of the case when the work has been done. The rejection of undesirable assets or contracts and the sale of unwanted or surplus assets are obviously super helpful because particularly in the COVID environment, but even in a more typical downturn, you usually have more than you need. And so you tend to want to exit contracts and assets that are no longer required under the plan. And you often need to renegotiate those components that are desired and are part of the future, but on a different basis. And so the ability to reject, or at least to threaten to reject contracts, is a motivator to bring everyone to the table. And then finally, we talked about the cram down, the fact that within bankruptcy in particular, you have the ability to negotiate with a certain core without being overly concerned about holdouts. If you can get that 2/3, you know that you've carried the day, and you don't have to worry about folks holding out, with a different view, maybe sort of an off-market view of what might be reasonable in these contexts. Now, the benefits to creditors, in addition to the predictability that we discussed, are transparency, I would say, and fairness. Right? It's bad enough that a counterparty is having to renegotiate its commitments to you. It adds unacceptable insult to injury if the process is neither transparent nor fair. Right? So I think whether it's a lessor or an OEM or a lender or anyone else, I think the counterparties, for the most part, can understand when events overtake a carrier for any number of reasons, and the carrier is unable to honor those commitments. But I think they at a minimum expect that the process will be managed in a way to be as collaborative as possible and to be as transparent and communicative as possible, so that they are not on the outside wondering what's happening, but rather on the inside working with you, sort of understanding, as we talked about before, the shared vision, right? Sort of developing that shared vision. And that means being very transparent with respect to not only their deal and why you're proposing what you're proposing and how you got there, but also what you're doing with other counterparties. And that flows into the fairness. And I think if people believe and can see that they are in fact being treated fairly, it makes it much easier to tolerate. It's still no fun to be there, but it's at least an acceptable resolution, as opposed to a circumstance in which they feel that they're being abused or discriminated against. Obviously, there are some costs to Chapter 11. These mostly fall to the airline and the management team at the airline, but they are to some degree borne by other parties as well. You have a high degree of scrutiny by the court and by creditors, which means if you're the airline, you lose the ability to, you sort of lost the kind of the business as usual that you may be, with which you may be more familiar, right? So anything that's out of the ordinary course goes, unfortunately does go to the court. And so that can mean that you're having to, at a minimum, you're having to undertake with an administrative burden of constantly briefing the court and the creditors committee as to what it is you're doing. But it also may mean in some cases that there are objections to those proposed actions, and that you may have to negotiate a little bit. So it's a more labor intensive and slower process just to sort of to do whatever it is you need to do, because the bar is pretty low as to what requires approval. You have heightened disclosure. That's a good thing for creditors, but it can be a nuisance for the airline. We would generally say, my colleagues and I would say that's usually not the worst thing in the world. If you're asking for someone's support and you're seeking to, you're looking for a concession of one kind or another, it's probably not unreasonable that you be fairly transparent, but sometimes those burdens can be fairly significant. You have quite a bit of inflexibility as to pre-petition matters. Those are, as I think most people know, given a subordinate status. So the obligations of the company that arise post-filing are, for all intents and purposes, given a higher, sort of a super priority. They effectively, with a few exceptions, they essentially have to be paid in full. If that's a, if it's a lease or a loan, it would mean that if you're not making full payment, then the asset is, after the relevant waiting period, is available for repossession and so forth. Or if it's an MRO or an OEM, then the requirement to continue doing work on say an engine or delivering an airplane. Those are the kinds of things that those are the areas in which those counterparties have quite a bit of leverage, because if they're not getting paid currently, they can for all intents and purposes tell you that they're going to stand out. The problem though is that in negotiations you're often trying to finesse what you owe them prior to filing, and all of that is a pre-petition claim. And so to the extent that the development of a fair or rational plan ideally would require some massaging of those differences, that can be difficult because they're by law thrown into effectively a single category. It's a pre-petition claim. You just add that to the other claims generated through the process. For example, non-compliance with return conditions in the event that you agree to return an airplane early, and that gets resolved back into the case. So it's not necessarily bad or good from either party's perspective, but it's different because it means that you may not have the flexibility. If you were negotiating out of court, for example, you could fine tune the approach, and you might be able and willing to pay somebody a little bit more of a recovery on pre-petition matters with regard to certain things, and pay someone less with regard to something else for reasons that are defensible and logical. And in Chapter 11, that can be very difficult to do. And then, of course, we talked about the costs and of the case. You have quite a number of advisors and lawyers and financial advisors and so forth, and it's a huge distraction to the management team. So the very powerful advantages of Chapter 11, the very effective tools that it brings, come with a cost, and they're not insignificant. So it's something that should be considered very carefully before a carrier seeks to file. So we've talked now about some of the substance of a restructuring and some of the process in court or out of court. But I think it's worth focusing for a moment on some of the principles that we think are important in any restructuring, and I think are just as true out of court as they are in court, just as true in a very narrowly tailored consensual restructuring of say leases or loans as they are in a full-blown Chapter 11 where the entire business is reinvented. And those include the sort of what I would say are the relationship to the big picture, the process, and then the substance. So starting with the big picture, I think the first thing to keep in mind for all stakeholders, but particularly airlines, is that the approach to the restructuring needs to bear some relationship to what's happening around them. And so what you would do, for example, if this is a carrier-specific restructuring, meaning a more garden variety restructuring where a specific airline has a particular problem, and the market overall is performing well. The global market is doing well. The regional market may be doing well, but this particular carrier has a problem or has a series of problems. That's got to be approached in a certain way. If it's a regional or if it's an international problem, as we see here with COVID, that's typically approached in a different way. So I think before you get into the process or the substance, taking a step back, I think it's important to calibrate the overall approach to the facts and circumstances surrounding it. And that's also true with regard to the breadth of the undertaking. So this could be a very, very targeted approach to address specific issues. And it can be a very narrow issue, but still have a huge impact on an airline. And so being narrow doesn't necessarily mean it's small, but it may mean that it doesn't touch as many stakeholders or as many parts of the business. On the other hand, in many cases, you have a wholesale reorganization of the business. You're leaving almost nothing untouched. And if you think back to that honeycomb, you may be looking at 2 or 3 of those, or you may be looking at all of those and then a whole nother ring around them. So I would say the carriers that are most successful are those that identify early on exactly what it is that they need to do and understand objectively how their restructuring fits into the broader global landscape, because none of their counterparties will be looking at this in isolation. They'll be looking at this in the context of their other exposures and their other relationships. So once you've calibrated in that regard, I think it's important to develop a process that is going to give you the very best chance of success. And in order to do that, I think you need to develop and maintain trust and credibility. Right? People have to see that you're treating them in a respectful and fair way. We talked about transparency. The plan itself has to be transparent, meaning sharing the revised business plan, the revised network, the revised fleet plan, all of those financial forecasts, everything that you have developed to inform your approach as a carrier needs to be shared at least at a high level or sort of a medium level with the counterparties, so that they can see it, they can evaluate it, and they can buy into it. Because as I said before, you can't really force anyone to do anything. The best you can do is persuade them. And if they believe the plan is viable, and they believe the management team has addressed in a sensible way the challenges that are facing the business, you're likely to have a very high degree of success. If the process isn't transparent, then at a minimum, it's going to be a slower, more adversarial process. And at worst, you very well may find creditors and other stakeholders not willing to participate at all. They may say, look, until you're willing to share something credible with me, I'm not willing to engage. And so it's the plan, it's the process, and it's the ask itself. Right? You have to be transparent as to what you need and why you need it of that stakeholder, but also of what you are seeking from others, so that they can see, not in a vacuum, but rather in the context of the broader landscape, how their participation fits in within the participations by the other stakeholders, both within their class, say other lessors or other lenders, but also other stakeholders. Right? What's labor doing? What's management doing? What are the OEMs doing? What are the shareholders doing? And so and that leads to fairness, right? So the trust, the credibility, the transparency, ultimately it leads to a feeling that this process is fair, that they are being treated consistently within a class, that what's being asked of them and what's being asked of others who are similarly situated is reasonable and is fair, and also that that other stakeholders are being treated in a reasonable manner, and that this process is fundamentally sound. Because it's not just a creditor will first assess whether what is being asked of them is reasonable and defensible and whether they can justify it. But they will also, if they're paying attention, and most are, they will look around to see how others are being approached and whether in their assessment others are likely to reach similar conclusions. And a creditor who senses that another creditor or another group of creditors is or are unlikely to participate at the requested level for whatever reason, will have a very different view about their own participation, because while they may be willing to do what is required in isolation, they may look at the rest of the plan and conclude that it's not being handled in the right manner, and it's going to falter for other reasons. And so all of this in developing the process, these are essential considerations, because before you even get to the substance of the ask, if the process itself is flawed, then it's almost inevitable that you will fall short on the eventual deliverable. So what is that deliverable? Well, in substance, I think it comes down to the proverbial carrot and the stick. Right? So there has to be a carrot, there has to be upside, which goes back to the shared vision and the alignment of interest. Each of these parties, whether it's labor or it's a lender or an OEM or a vendor of some kind, they have to believe that there's a reason to participate. Now, the reason it can be different in different contexts and different circumstances, but at the end of the day, it tends to fall into sort of broadly the category of because it's better than my alternative. Right? They have to believe that participating in this restructuring is better than pulling the plug. And so there are a number of manifestations of that. There are a number of variations on that, but broadly they have to believe that there's some upside to them, which is a better recovery and a better result over the long run than their alternatives. And there has to be, or I would say usually should be a little bit of a stick, which is to say, look, it's not participating, holding out is not an option. And that's one of the reasons why out-of-court restructurings are so challenging, because there's often not much of a stick. you're often you're asking counterparties to recognize that things are unsustainable and to sort of do what's in everyone's best interest, but without any sort of explicit mechanism for the prevention of free riding, right? So people can say, hey, that's great. We see that your plan is credible. We can see that you need X or Y or Z, but we just assume you'd get it from someone else. So we're going to sit back and let the others participate. It's hard in certain circumstances. It can be hard to corral those parties when you're in a sort of, if you're in a scheme of arrangement or you're in an insolvency proceeding, it's a little bit easier because you can say to people, look, whether you participate or not, this is what's happening. We're going to present something to the majority of you or to all of you. And if a significant majority of you buy into it, then it's binding. We can bind you, the holdouts. And so you might as well, there's an easy way or there's a hard way, but one way or the other, you're going to get to the same place. And so you want a pretty healthy carrot, but it helps as well to have a little bit of a stick on the back end. You want to make sure that it's clear that there's shared sacrifice, right? That you are not asking creditors to do this on their own, either vis-a-vis the airline itself and equity, or one versus another, right? You don't want a lessor to see that you're not touching the lenders. You don't want a lessor to see that you're not touching the OEMs. You don't want an OEM to see that you're not touching lessors, right? You don't want the labor to see that you're not addressing other areas, or vice versa. Each of these parties has a reasonable expectation that others are contributing, and similarly, financiers in particular and major trade creditors will expect that you're going to respect the capital stack, right, and where they fall within that. So that means typically that they expect equity to be impaired, right? If you're asking a lessor or a secured lender, for example, to mark to market or to take aircraft back early, or otherwise to provide permanent savings to the airline, they will tend to expect that there's at least some recognition of that, some dilution, some impairment to equity, which sits below them in the hierarchy. So, and that's a very tricky and very controversial element, and it's different in each restructuring, but in one way or another, it must be addressed, because one of the surest ways to frustrate a creditor is to explain to them that all of the sacrifice necessary for the restructuring is coming from people with priority claims in order to protect the equity at the bottom. And we've seen any number of airlines try this over years, and it almost always ends unsuccessfully. So there has to be some acknowledgement that equity is participating as well. You have to distinguish as an airline, I think, between what you want and what you need, and what you can, and indeed what you can afford. And so you want to make sure that the ask is defensible. It may be defensible in one respect, which is, okay, there's enough market duress that I can kind of get away with this, but is it really necessary? Are you overreaching? Are you seeking more support than you need or than you can justify? But similarly, in what it is that you're proposing, is it affordable? Right? It cuts the other way too. You've just signed up for X, Y, or Z. Can you deliver? Or in a year or two, are we going to be back in some kind of an out of court or worse in court process? Right? The one thing that every creditor hates more than Chapter 11 is Chapter 22. And so if you're going to restructure obligations, you better make sure that you can actually honor them, right? That the plan is viable, and that whatever it is that you've promised that you will do is in fact affordable. And finally, I would say that you really want, as an airline, if you're seeking to restructure in the most successful manner possible, you want to make it very clear that you are committed to minimizing the harm to the other parties to the fullest extent possible. And that's a broad principle that can be manifested in any number of ways. But at the end of the day, what you're saying effectively is that we're not going to use the leverage that we may have to squeeze you. Instead, we're going to look for ways to be cooperative. And if there's something that we can do for you that's relatively inexpensive to us, but helpful to you, we'll do it. Now, inevitably, there's a little bit of a negotiation, and you will sometimes see parties jockeying for for leverage or playing their cards a little bit closer to the vest in order to maximize the recovery or the result, the expected result. But I think broadly, if the parties recognize that they're all in this together, and certainly with COVID, with the global pandemic, that's never been more the case, right, than it is now. I think you can earn in the medium to long run, more goodwill than it will cost you in sort of sort of foregone savings opportunity or out-of-pocket expense. And so I won't get into all the details. There are dozens of ways that this manifests itself, but the principle I think should be that you're not trying, as an airline, you shouldn't be trying to exploit the leverage fully. You should be identifying what it is you really need, addressing that as quickly as possible, presenting it in a fair way, persuading folks that indeed it's no more than necessary, and then getting out. And that's doing as little harm as possible to the counterparties. Lord knows in this environment, particularly, they're already giving quite a bit. The impairments are extraordinary, whether it's a lender or a lessor or an OEM or any other trade partner. And so you don't want to add insult to injury. You don't want to make it any worse than it needs to be by being careless or thoughtless. So there are ways to craft an ask that respects and reflects the unique sensitivities of that particular counterparty on their facts and circumstances. So finally, I'll end with my favorite slide, which are a few of our observations on the crisis today. So on the airline side, I would say the first observation is that we talk quite a bit about the fact that this COVID, right, has been totally unprecedented. We've never seen a decline in demand of this magnitude ever in the history of the industry. But at the same time, it wasn't truly unforeseeable in the more literal sense. We talk as an industry all the time about the risks that we face, the fact that it's a very vulnerable, very dynamic industry. I myself have spoken publicly and listed the risks of pandemics. So it's usually at the end of the list. We talk about the usual cyclicality. We talk about terrorism. We talk about fuel. The pandemics are usually tacked on at the very end, and we often don't give them enough thought, perhaps. But they were there. We knew we saw it with SARS. It's not like a respiratory pandemic is truly new. We've seen it before. We saw swine flu. We've seen downturns before, and I suppose one takeaway is that on the airline side, we probably need to rethink the degree of risk we're willing to maintain. Not suggesting that we target cash as 30 or 40% of LTM revenues. That might be excessively conservative. But I think as an industry, there are things that can be done to better address foreseeable but unlikely risks. I think as human beings, we tend to be naturally optimistic, and so we tend to discount risks that we think exist but are more theoretical in nature. And I think we've learned that this isn't this. I think at this point we can't say that this is unprecedented. We can say it now, but we won't be able to say it hereafter. I think we'll have to prepare a little better for the downside, and that in a number of different ways. But I think we also have to recognize that whether it was unprecedented or not, or indeed even unforeseeable or not, it has clearly exacerbated pre-pandemic weakness. And so I think at one point, I haven't tracked this all that closely, but I think here in the U.S. at one point, the Center for Disease Control was estimating that some 94% of the deaths in the U.S. Were from officially attributed to COVID, were actually associated with other conditions, heart conditions, lung conditions, so forth. And so they would describe this as comorbidity, meaning that it was a contributing factor, but not the only factor. And I think indeed that's what we see here. Airlines that are facing the deepest restructurings, and indeed some the airlines that may fail, I think for the most part had pre-existing conditions. And so while COVID is an aggravating factor, I think we have to recognize that a number of airlines were benefiting from the very sustained and very prolonged tailwinds of the last 10 years or so, and had not maintained in some cases the discipline that they needed. And so while COVID is a catalyst to change, it may not be the only factor here. And I think I think the carriers that recognize that and are willing not only to address the COVID-related declines, but also reassess whether the business pre-pandemic was really where it needed to be, are the carriers that on the back end will be stronger than ever and will have done more than survive. They will actually have put themselves in a better position to prosper. I think it's also important to note that at the same time, to be fair to carriers, that different business models and geographies have fared differently. And so this is kind of the opposite of the comorbidity. While I think it is true that most carriers in the deepest distress today are there as a result of a combination of factors, of which COVID is only one, I think it's also interesting and noteworthy that the impact of the pandemic has been uneven at best. You know, carriers that are more exposed to international flights clearly are more severely affected today. Those that are more domestic and that have a larger domestic home market are far better, right? Far better able to withstand the stresses. Those that have more short haul flying, the same thing. Those that are more leisure and VFR, same thing. And so you could have two carriers that pre-pandemic were of equivalent caliber, similar balance sheets, similar operating margins, sort of similar sort of intrinsic strength in terms of their competitive positioning, that have dramatically different results because of the nature of their businesses and what that means today. And that's before you look at the impact, the disparate impact of government aid. Right? Some governments have been very generous and have had the financial wherewithal to extend very significant support, and other governments have not. And so where you are has in some ways become just as important as who you are or how well you are performing. And indeed, another related but distinct consideration, I think, is that there are significant disadvantages in this market to strength. We normally would say that in a recession, whether it was the Great Financial Crisis or 9/11 and SARS almost 20 years ago or whatever it may be, we would almost always say that the healthier airlines, the ones with the healthiest balance sheets, the highest margins, the best management teams, the best brands, those were the best positioned to survive the inevitable downturn. And those were the carriers that are the long-term winners. And that's generally true. And indeed, I think it's almost exclusively been true today. Very few examples of carriers that were weak heading into a recession that somehow benefited from that. But in this case, I think there's a potential for what I would call compression and leapfrogging. And by that, I mean, if you were to rank within a given market, the carriers pre-pandemic, you might find that the carriers at the top suffer some degree of compression by the time the dust settles and we're through all of this, whenever that may be. You may see that they actually have the margin by which they are outperforming, they are healthier than their competitors, may actually compress because rightly or wrongly, fairly or unfairly, some of the weakest carriers, because of their weakness, are having to tackle these issues more aggressively and more completely, and may indeed emerge on the back end stronger than they entered the crisis. And so you may even see some leapfrogging, where you see a carrier that effectively overtakes, in an extreme example, overtakes a peer that was less able to restructure because of their ability to honor their commitments more easily. And so it's a tricky spot, and it's the only case in my career in which I've seen management teams and business models punished for superior performance. Some of the better carriers today are less able to restructure than some of their weaker competitors. And so I do think there will be a reordering a little bit, or a compression. And in the very long run, that may not make a difference, but I think over the next 5 or 10 years, it could be material. And I think, and it's what I've said to a number of clients over the last 4 or 5 months, is that I think the goalposts are moving. And so if you're a relatively healthy carrier, your benchmarking, like what you thought was appropriate, particularly on the CASK side of the equation, is different. I think it will be different on the back end of these restructurings. And so if you're essentially surviving and running in place, your reward for that, and your reward for not having to restructure any of your commitments, is that many of your competitors have taken cost out and taken capacity out and done these things a little bit more inexpensively or more efficiently. And so your relative advantage may be compressed. So it's a tricky spot. I suppose it's if you're a weaker carrier, mid-tier or weaker carrier, it may be a good thing. Right? You have a little bit more upside, more opportunity. If you're a stronger carrier, I think it's probably a bit of a frustration, and it's in any event, it's a complexity. And restructuring that we, in this pandemic, rather than this downturn, that we've not ever seen before. On the investor side, look, I don't think any of this is revolutionary, but we've seen that market conditions and remarketability at the end of the day are the most important factors in anything. Right? We've talked endlessly at ISTAT and elsewhere at conferences all around the world for decades about Section 1110 and Cape Town and contractual provisions and protections and so forth. All of that matters, but it never matters as much as the prevailing market conditions. We saw that in 9/11 when I was at United during that restructuring. We saw in spades that it really didn't matter. Yes, 1110 was alive and well. We did our best, to work within it and to be creative and try to protect our fleet as best we could. But it was mostly not because of what we did legally or commercially, but rather because the market was so depressed. And so today, of course, what you see is an even more extreme version of that. And so when a counterparty doesn't have anywhere to go with the asset, it really doesn't matter whether you can or can't seize it on the 60th day. So I would say we've seen, not that any of us have forgotten this lesson, but I think we've been the lesson's been reinforced. I think that at the end of the day, the most important thing is the marketability. We've also seen the pre-pandemic supply or oversupply of kit, right? So we've seen many of us thought and discussed publicly for the last 3 or 4 or 5 years that levels were very, very high, and that likely was going to create problems in the next correction. We certainly didn't expect this kind of a correction, but those pre-existing conditions, again, it's a little bit of this comorbidity. This is the lessor version of that, or aircraft financier version of that, or OEM version of that. There was already very, very high supply, and so when you suddenly take demand out, it makes that much more challenging to navigate. And of course, we've seen with the MAX delays a wrinkle there, which is the disproportionate cancelability of that order book. And so it's created another swizzle on top of an already very dynamic situation. We've seen that we entering this crisis, we're at a point of peak, I would say peak penetration of the leasing product. So we have more 100% financing, I would say, than would have been the case, say in the United restructuring when we filed in 2002. So you've gone up by probably 10 to 15 points. And so that creates, again, more downside risk. We've seen a huge influx of new capital to the space, and also the significant increase in the number of participants. I think most will survive the storm, but not all. And I think they're not equally equipped to navigate this kind of a crisis. I don't think this is what some of them signed up for when that capital got into this space. We have huge order books, and we've talked about that. ISTAT has discussed that very extensively over the years, but we've seen enormous order books, and so that has particular ramifications when we suddenly see a demand shock like this one. And then finally, we see, as a result of the unique and this is truly unprecedented global travel restrictions, it's nearly impossible for all practical purposes to travel internationally to inspect or to redeliver or repossess aircraft. And so it's not, I don't think too many people were rushing to grab their assets, but even when you think about consensual lease returns and so forth, rejections and bankruptcy and so forth, it's just, who would have ever thought that physically getting technical reps and getting crews and so forth to the asset would ever have been the issue. And so there are quite a few, on the investor side, there are quite a few complexities that we wouldn't have seen in prior downturns or in prior periods of crisis that are unique to COVID and to the confluence of factors here. So I apologize for moving quickly. We had a lot to cover there, but I think with that, I will pause, and I had endeavored to leave enough time for Q&A. So Niels, maybe I can turn it back to you, and you can let me know if you or anyone else has any questions. And Niels, I don't think we can hear you.
So can you hear me now?
I can hear you now.
Okay, good. So thank you so much for that, Doug. And I have a few questions here. The first one is that as we go through this pandemic, there's going to be a number of airlines that will restructure and mark-to-market liabilities and adjust costs and adjust fleet sizes and so on and so forth. And then there are others who will, so to speak, behave through the pandemic, and they will, load on a lot of debt, maybe get new equity injected, and they will perform. But behind the pandemic, isn't there a risk then that those airlines that, so to speak, behaved will be at a competitive disadvantage and may have to restructure in a sort of second wave of restructuring?
Yeah, I think so. And that's a little bit the compression or leapfrogging that I was describing. So I think the carriers, to be honest, I think the carriers that are benefiting the most, or to say it differently, that are suffering the least from the pandemic are those that had fairly significant problems already and that now have the opportunity and the willingness to address them. And so in some ways it's a silver lining. There's a silver lining for them in that this can be the catalyst to real change. They can reinvent themselves perhaps in a way that they could not have or would not have but for the pandemic. So yes, I think the carriers in the middle, sort of the lower half, if you will, are disproportionately aided by this dynamic, and those that are, as you're saying, sort of behaving, those that are honoring commitments as they come due, maybe asking for modest deferrals, but in general meeting their obligations and not seeking any kind of permanent concessions. I do think those are the carriers that suffer the most, and I think there's a degree of inequity there, and it's a challenging issue because there's the very nature of their strength is what makes it difficult to approach a restructuring now and to maintain some level of relative parity with their less well-positioned competitors. That's what I say when I think the goalposts are moving. I think the margin by which they are ahead of the pack will have changed potentially very significantly by the time the dust settles.
Okay, thank you. So the other question I had was that we talked about airline restructurings, and I mean, they kind of are the lowest in the food chain. That is where the cash is generated that goes into to the different creditors groups. But do you see a risk that if this restructuring pandemic would spread into lessors, banks, vendors, OEMs, and MROs? Because they are the ones who get paid by the airlines who are suffering.
Well, there's no question. The whole ecosystem has been shocked, and certainly the first thing we saw was the passenger, right? The very first thing, the canary in the coal mine was the individual traveler who stopped showing up, and so the airlines were the first to be impacted. But that does flow through to the airports, to the lessors, to the lenders, and to the OEMs and the MROs. And so there are very, very few stakeholders within the ecosystem that are not affected. And I do think lessors have become a bit of a shock absorber, and they've borne quite a bit of the burden. And look, we've seen with NAC already a restructuring. They may not be the last. We could see a little bit of consolidation. We could see a few reorganizations of their own. Many have the benefit of being associated with very, very large, well-heeled financial parents. And so I think quite a number of them have the scale to weather the storm, but there's no question that it's creating distress for them. And so I think it's a space to watch carefully. And I think quite a few will weather the storm, but I do think certainly at the margin, there will be more than a few that have to engage in restructurings of various kinds of their own.
Doug, you work for a very famous restructuring advisory company, but there must be a lot of demand now among different players. So what does the restructuring advisory landscape look like? I mean, who are your peers and competitors, and why should somebody come to Seabury rather than to somebody else?
Sure. Well, we are quite busy. We at Seabury and our peers as well. I think we're all as busy as we've ever been. Not in the best of ways. I think we'd rather be busy arranging financings for new airlines or advising them on new orders or fleet trades and so forth. But yes, our firm, as you may know, was formed 25 years ago by the then ex-CFO of a major U.S. carrier that itself had recently restructured, and he saw, I think, rather presciently an opportunity, sort of really a market opportunity for a dedicated boutique that was focused on restructurings. And so he and the founding partners capitalized on that opportunity, and for the last quarter century have built what is sort of we consider to be the largest and we would argue arguably the best airline restructuring practice. But whether it's Seabury or any of our peers, I think there's a huge opportunity, and it's become part of our DNA, so much so that people tend to, people joke when I'm at an ISTAT conference and they see me walking in their direction down the hall, they clutch their wallets, right? I mean, it's the restructuring element of our business has become such a huge part that it is, and certainly today it is the dominant part of the practice. But I think that's true. I think that's true for a number of others as well. And even if they don't have the history, I think in recent years we've seen other boutiques present themselves. I was at Skyworks until a few years ago when I agreed to come over to Seabury. Skyworks actually split off from Seabury I guess it would have been about 15 years ago. And it's a great shop, and with a really good team. They're a little bit smaller, but they do very good work, and they're quite busy now. We've seen a couple of other firms, Plainview Partners, for example, which is also younger still and smaller still, but they're active in the space. So we've seen a couple of other airline-oriented boutiques, and then of course you have some of the larger the larger firms that don't specialize in the space, but that have a relatively active practice. So you'll sometimes see an airline call on a generalist and not look for an industry specialist. Now, I would tend to say, in my experience, that's often a mistake, and we would, whether it's Seabury or one of our competitors in the boutique sector, we would tend to argue that it's a very specialized field, and we would say that there's usually a really critical role for a specialist to play. But in some cases, you'll see other firms that are more generalist by nature advising on an airline. So I'd say whether it's Seabury on the one end or a generalist at the other end of the spectrum, I think we're all quite busy. And what's interesting is that there's so much work, and I think this is an unfortunate testament to the magnitude of the challenges facing the airlines. We're actually seeing a significant uptick in requests for lessor and lender side representation. So we tend to be associated with airlines. We do represent investors fairly actively, private equity firms, hedge funds, and leasing companies and so forth. But we're most typically associated with airlines, whether it's in restructurings or other contexts. But lately, what we've found, particularly over the last 6 to 8 weeks, is that a number of airlines that seem to be or seen by the market as fumbling around and not approaching a restructuring maybe in the most thoughtful or successful ways are inspiring enough sort of, I would say, consternation in the creditor community that those creditors who normally would advocate on our behalf on an airline side representation, meaning normally would lobby an airline to retain us for sort of mutual benefit, are now growing concerned and exasperated and coming us directly to advise them on the other side of the table so that they can protect themselves against what they see as abusive or less than helpful practices. So I would say that we individually at Seabury and we as an industry are very, very busy on airline side engagements, but I think increasingly that's actually flowing to the other side of the table as well.
Okay. My good friend Michael Dalsing down in Florida, he was asking you to comment a little bit on slide 4 in your presentation, where you show the 3 different phases of the restructuring process. Where would you place Aeromexico, Avianca, and LATAM in that process at the moment?
Sure. I can pull up. Let me do this. I'll go back for Michael. I can go back to. Let's see if. Probably.
Yeah. Sorry, it was slide 5. Yes.
Sure. So I would say they're squarely in Aeromexico, LATAM, and Avianca. I would say are squarely in the 3rd column, which is in this case Chapter 11 in the U.S. They are, and I would say they each got there for similar reasons. Right? I talked about the fact that you have the most typical, the most common undertaking in Chapter 11 is a so-called traditional or free fall filing, where you file because you have to, because there's something it's usually a payment or there's usually an upcoming payment or some other trigger that creates significant operational risk to the business. And so I would say all three of those they're clearly all in Chapter 11. And I would say they're also clearly in the traditional case, which is that you file, you avail yourself of the automatic stay, and then with the relative stability of Chapter 11, you develop a plan and then you negotiate with the key stakeholders. So I would say those three are very much in that lower right corner.
Yeah. Okay. Doug, you mentioned that there has to be a need for a restructuring. I mean, the airline has to identify the need to do something, otherwise it will not survive. But isn't it very tricky in this crisis to really understand your needs, because you don't know how long the crisis is going to last and you don't know how deep the damage is going to be. So how do airlines address that uncertainty about the future when they go through the restructuring process?
So that's a really good but really tough question. I think the short answer is that you have to run sensitivities after sensitivities after sensitivities. And I think on the demand side of the equation, and we have a very strong, one of the things that I think makes us, has helped us to create a leading platform in restructurings. It's not just the work that we do on the banking side, colleagues folks like me who have more of a transactional background, but also our consulting colleagues on the network and fleet and revenue management sides. And so, for example, we have quite a number of specialists that look at this very, very closely. And for each of these engagements, we're modeling a number of different demand scenarios, and it's not one, right? We have the crystal ball is particularly cloudy at this point in the crisis, and so we have what we're typically looking is to identify two or three or four different demand scenarios, and to model. You can't at one extreme, if we take the position that we're not going to see a recovery for another 2 or 3 years. The reality is virtually no airline would be able to survive without a bank, insolvency proceeding of some kind, right? Unless there were continued government support, but I think at some point even that runs out. So if you take too negative a view, then everyone's filing, and we're all, every fleet's getting cut by half. On the other hand, there are some who would expect a relatively quick recovery, and I think that's probably a little bit irresponsible. And somewhere in between, you can run, and we do run, a variety of scenarios that reflect what we think are the highest probabilities. But there has to be a little bit of a cushion, because you don't want to build a plan and spend 6, 9, 12 months in this process and have a plan that works only in a very narrow quarter of recovery. It has to be broad enough to capture a realistic range of outcomes, and that's what we're doing. And so I guess what we would say is we want to make sure that with respect to capacity, number one, with respect to capacity, that airlines are not carrying more than they reasonably need. And certainly PBH structures help quite a bit, and those have become very, very popular because it creates a natural degree of flexibility. But we would say returning aircraft that realistically will not be needed under any plausible scenario, creating PBH type structures, raising as much liquidity as possible. If you end up a little bit too much liquidity and you paid a little bit more in interest expense, I think that's a high class problem. You'll look back and you'll say we did the right thing. If you didn't raise enough and you're scrambling later, that's a more challenging position in which to find yourself. So there are a number of things with respect to demand. There are a number of things with respect to liquidity, but above everything else is to prepare for a range of outcomes.
Okay, thank you. We have one more question that I think we have time for, and this is Gerald Hirso that is asking. He's saying, I don't know if he works for a law firm, but he says that they are typically advocating their clients to repossess aircraft as early as possible, no matter what the repossession and storage costs will be. And the rationale for this is that, a distressed asset is much more likely to devalue in a crisis, and the lessee not being able to maintain the aircraft properly and keep the airworthiness. What would you comment or say to that?
So I wouldn't necessarily paint with quite as broad a brush. I think it depends on the facts and circumstances. If there are genuine concerns about the viability of the business, if it's a business that very possibly may fail, then accessing the collateral may make a lot of sense. Similarly, if there are concerns about cannibalization, if there are legitimate documented examples of mismanagement of the asset, then I think I would tend to agree that securing the asset creates a floor on the recovery, right? So you know that at least the asset's protected, and when market recovers, you'll have an opportunity there. I would say, on the other hand, though, with carriers that have demonstrated that they behave in a respectful and lawful way, that are operating the aircraft, either storing it appropriately or operating it on some limited basis, I think I would counsel an investor or lessor client probably to take a more measured view, because the one thing you know is if you pull the asset, you're now at a disadvantage in the recovery with that airline, right? It's much less likely that having pulled it, that you're then going to place it back with that carrier. On the other hand, if you've remained with a carrier, either in storage or in some sort of level, in some degree of ongoing utilization, it's more likely that as things recover, your asset gets flown, and you benefit in the nearer term from that cash flow, and in the longer term, hopefully, from the retention of that asset. Whether it's even if it gets marked to market in some capacity, you're better off generally remaining with that carrier and avoiding the transition costs and expenses and so forth, right? I mean, if you pull it, you know you're never going to do better than market, right? You're going to place it somewhere else at market, and so you've got the repossession, the storage, possibly the reconfiguration, and then at the end of the day, after all that, you're rewarded with nothing better than a market rate. If you leave it with a first carrier, as long as it's being protected reasonably, and if it's being flown a little bit, you get some cash flow in the interim, and you may end up with likely at worst a market rental if you have a full mark to market, or at best something above market. So I guess I would say it really depends on the circumstances, and I would probably not attempt to give a single answer for every circumstance.
Yeah. All right. Thank you so much, Doug. I think we're running out of our time slot now. Thank you so much for having given this very interesting presentation. Thank you to everybody who listened in, and see you back on December 1st to talk about China. And I hope I will be able to fix my internet issues by then. Thank you, guys. Bye-bye.
Take care.